applications were filed online to get some things right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kirugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge. My Lord, just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet, and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files would now be before the bench formally so. Right?
Yes, my Lord, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications and to take...
No, Mr. Let us finish with quorum first. There's a quorum in E013, which was consolidated in Gachagua with E014. Just take quorum on that file.
Something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, either team was not part of this call, have not had it perhaps with the report. Your Lordship, in E015, there has never been a consultation. To the best of my knowledge,
why are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, Your Lordship, then there is a run that is made.
My Lord, may I say something?
Let me answer him. You said that record speak for himself. And for record, matters which came from Karagoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Karagoya was already consolidated. Those proceedings which took place in Karagoya consolidated these 2 files. So let that not be an issue here, please. Now, on the directions issues on 11th by Judge Richard Mongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Responded to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Karagoya under the Karagoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Karagoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Karagoya court were given those orders. Those were your orders.
And with your permission, presiding judge, the reason why Nairobi has not opened another file to put together all the files from Karagoya is this. Going by the orders which were issued by Karagoya court, there was a specific order that because of the transmission, parties will still file their documents under the Karagoya CTS, that is the contracting system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place. Thank you.
I presume we will now raise the issues that were raised, particularly arising from the issues of Karagoya.
We will then proceed and take quorum on it. They were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated the important. I need to raise some clarification.
Section 7 of the Attorney General's Act.
You had read your subject. It doesn't override my right to represent my client.
I'm repeating.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
We have 0115.
We have several.
We have 0115.
My Lord, I wanted to say that
Yes.
the only matters before this court are the matters which had ex parte orders. The matters that came from Karagoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders. We have E15.
E15 has
Conservatory orders, but E13 and E14, although from Karagoya, they were filed before impeachment and they had no
My Lord, I'm leading the number of advocates in this matter from Nyaga. Yes. Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of under the 2010 Constitution. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordships, that you are convened by the Honorable Lady Justice Willie, the Deputy Chief Justice. Lady, my Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We will be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may I?
I think I have a right to raise those issues.
Professor Mugai, just give Philip Mugai time to...
I just wanted for good order, my Lord, if I may.
Clarification, Mungai.
I am Mungai. I believe he will speak in response as soon as
Proceed.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Mungai was a former Attorney General. I respect him. He was my teacher, my professor of the criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and as before the court, I should be heard in silence, he will respond. And I have indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Mulima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they will sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications will be on what basis would, in an application by the executive, be convened on a Saturday. That is a substantive issue because of the second reason that background that we are giving. provide for the Bill of Rights. My Lord, under the former constitution, we used to have a practice in which we had an officiary, a bill of immunities for the state, a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made in Asatari. And my Lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My Lord, for purposes of Article 165, I believe it's 4, of the Constitution, is to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165, 4 of the Constitution. And we shall place here the Deputy Chief Justice a formal application. Issue number 2, my Lord, arising from that.
You have meant that we discharge the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. Well, my Lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday city and today's city, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that we have made. But I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue is big for the Wananchi and with a clear conscience. 2 things. But the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable
I think, Mr. Mukai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you
Let me raise another issue that does not have to do with those prayers. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, There are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? There are an express order of the court that has not been set aside. The question will be this: for purposes of good order and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have noticed, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But why I say, as I go to see, why I say this is important is this: the matters before you over and over again, the repeated question has been that the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible.
Mr.
So that, my Lord,
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
that is what
But if you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
Well, just to add on what my lawyer has submitted on.
With the permission of the presiding, I wish to say I wish to make this clarification. The matters which are before us today, the 3 matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and you dealt with online. That is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senior Counsel Mute and Counsel Ndegwa, when you argue the way Mr. Mugwe has argued, that court sat on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai. Let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't finished. In E015 in the report, the Deputy President is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Oboya will be making submission. But my Lord, do give us, these are very weighty matters. This E015 in Kiroboya, the orders of your brother, Mr. Justice Mungu, were given at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday? Permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the President that will be set for the removal of Deputy Presidents in future and the removal of Presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Mwite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this court.
There's no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on 165 cross 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empanelment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That is why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally satisfied as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued to someone us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority? And the files with orders are the only ones that the court is sitting on a Saturday? We are called, like in the letter in speak, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the simplest point in his opinion. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties in these proceedings. So it would be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the rules of the court. So in this regard, my proposal is as follows, that each of the party who has whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we are able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and so on. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issues, because the federal respondent has a pending application which is being filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter related to the nomination of a presidential and overhead to the president, which in our view lies squarely within the domain of the Supreme Court. So we want accorded opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
For the first interested party,
conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which I
We
are now making an application in response.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165 clause 4. Your Lordship, and whether if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165 clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empowered to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerogoya, was equally selected for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
Appearing for Professor Kibiki, listening to my colleagues, he is making an application